Now, Mr. Marby.
My Lord, the issue between the parties is a narrow issue because the respondent's submission is that somebody who experiments with explosive substances, whether they are a university professor or a private individual, may have a lawful object depending on the circumstances. But at the heart of this appeal is the question of what it is that someone in the accused position has to prove in order to establish that he did have a lawful object and therefore that the offence, the statutory defence, is made out. And what the respondent submits is that it is not enough to say, I was curious and experimenting, because that is not the object for the purposes of Section 4. The object for the purposes of Section 4 is not the curiosity or the experimentation, it is how the explosive substance is going to be used. And in order to establish whether that use is going to be lawful, an accused has to identify how it is going to be used and has to prove that on a balance of probabilities.
Well, in his defence statement at the moment, he's explained why he made it. If a charge is going to be amended to make it unequivocally a charge of unlawful possession, presumably he will have to, or he will, I imagine, put in a revised statement explaining what the object was of his possessing the substance. Well,
as the respondent understands it, the object is the same. It is to detonate.
Well, we went into this before the adjournment. One could expand that somewhat. I mean, is it to do with experiment? I mean, it may not sound very good, but effectively it's bomb making, if you like. I mean, it's experimenting with methods of testing the explosive qualities of the substance and how it might be detonated.
My Lord, yes. But there's an onus on an accused to identify how that's going to happen and whether it's going to be lawful.
You mean as a matter of pleading?
As a matter of pleading and evidence. Because what's happened at the moment, my Lord, is that a defence statement has been submitted and the trial judge has been asked to rule whether the matters set out in the defence statement are capable of establishing the defence. But at the moment, there's no evidence as to how these explosive substances were in fact going to be used.
Well, evidence is a matter for the trial. So you're wanting notice to be given in the defence statement of what the tenor of the evidence is to be.
Yes, because...
Well, I don't know. Is that what you're wanting?
Well, what the judge has ruled at the moment is that these matters in the defence statement of themselves are incapable of discharging the onus on the appellant, because what was being said, and this was evident from the litigation in the Court of Appeal, the appellant's case was, experimentation is of itself lawful, and therefore, if that is right, if I was experimenting and that's accepted by the tribunal fact, then that's a lawful object.
Well, it's got to be more than that. It's got to be that is the purpose. Research and experimentation are the purpose. I mean, there may be then questions, well, research or experimenting for what? In which case you may have to go further, but he's just saying that was my purpose. What's wrong with that?
The respondent's submission is he does have to go further.
Why?
Because it's simply not enough to discharge the burden, to say I was experimenting, because the experimentation is not the object. The object is how the explosive substance was going to be used in his case.
I'm very slightly confused, because I thought the certified question at page 68 is all in terms of, for the purposes of Section 4, can personal experimentation or own private education, absent some ulterior unlawful purpose, be regarded as a lawful object?
And the respondent's answer to that is no, that's not the object. A person who is experimenting may have a lawful object, and they will have to identify that, and that includes identifying the circumstances in which the explosive substances are going to be used.
But that's not I don't understand. I don't understand what you're meaning. Are you meaning that the experiment has to have some ultimate further aim beyond the advancement of the person's education and understanding? Or are you saying that something about the circumstances in which the experiments are to be carried out, or the nature of the experiments, has to be explained in greater detail?
It's the latter, my lord. And can I?
But why is that needed? I mean, as a matter of criminal procedure, why is that necessary?
The respondent submits that's necessary in order to discharge the burden, to identify, to prove how the substance is going to be used. And unless that can be done, an accused can't prove that the use of the explosives is going to be lawful. And what underpins this is the burden that's placed on the accused to identify the relevant facts.
But, I mean, the statutory language is simply lawful object. I mean, that seems quite a broad concept. And at first blush, speaking for myself, if one says, well, my object is personal experimentation or the advancement of my understanding, that seems to be an object just as a matter of ordinary English language, but you seem to be saying it's not.
Well, the point that the Court of Appeal, I'll take my lord to it in a moment, the point that the Court of Appeal made was somebody may be curious, somebody may wish to experiment, but they could do that by detonating the bomb in a crowded area. And the way the Court of Appeal analysed it was it's not the motivation, it's not the curiosity that is actually the object, it is the end use. So it's the exploding the bomb in a public place, which is the object. And the fact that somebody is curious and wanting to advance their own self-knowledge isn't the object, but simply an explanation
Well,
of past events.
What's the object of chemical experiments in a school or a university? I mean, leaving aside research that might be carried out, assuming usually it's education.
But someone who is the university professor, in order to show what the object is, would have to go further than simply to say it's to advance knowledge. The university professor would have to show the circumstances in which the explosive substance was in fact going to be used. That is part of the object. It's not simply a motivation.
But I don't understand that. I mean, the object is just a synonym of purpose. And on the face of things, experimentation is a lawful object. It might not be if the nature of the experiments was itself unlawful, but that'd be a matter for that'd be a matter to be raised at the trial, I suppose. I mean, all that's needed at this stage is for defence to prove a lawful object.
On the facts of this case, for example, the appellant has not identified the circumstances in which the experiment is going to take place. Now, the respondent's submission is that means he's not able to identify what his object is. There may be a whole range of circumstances in which these explosives are going to be used, and no one knows. And it may be that the Appellant himself doesn't know. He simply has them because he's interested in them. But, and so what the respondent submits is that that absence of evidence as to the circumstances in which the explosives are going to be used does go to whether or not any object for the purposes of the section can be established. And but before I go to the Court of Appeal, can I say that...
Well, the Crown obviously have a mobile phone. They've got his own records on film of the experiments he had been carrying out. And they know how much material he had, apparently a tiny quantity. Is there anything to suggest that the experiments would be unlawful? Is there anything unlawful about what he was doing, setting off miniature explosions in his back garden?
There's simply an absence of any information in the defence statement.
So are you saying that if he said, I'm not even sure quite how one would frame it, but if he said something like, my object is personal experimentation to the level of about setting off a firework, that would be fine?
Well, it would depend on all the circumstances, but
why wouldn't that be a specification of circumstances on your theory? You would want even more than that. Would you want him to sort of set out each notes of each step in how he would go about preparing, as he understood it, the firework level explosion? Is that what you're saying would be required?
There would need to be a degree of he would need to satisfy the court on a balance by producing specific evidence and a specific explanation as to what was going to happen when he detonated the explosive substance.
But what if he happened to know about the 1875 Act and said what I was doing was for the purpose of chemical experiment and not for practical use or for sale, would that be good enough?
It wouldn't be good enough, Mike.
Wouldn't be.
It wouldn't be good enough because it simply wouldn't explain.
I mean, if the 1875 legislators thought that chemical experiment could be a purpose and a legitimate purpose if it wasn't for practical uses, why should we read something more into this statute?
Well, it can be someone experimenting in that way can have a lawful object, but the focus isn't whether in the abstract or in principle whether someone could have a lawful object. It is, does the accused in these particular circumstances have a lawful object? That inevitably requires a focus on what it is he is actually going to do, and that's for him. There's no onus on him to prove that, both what he's going to do and that is in fact going to be lawful.
But why doesn't it work in this way, that in his defence statement he specifies to the level of detail that he has, I want to do this for experimentation and personal education, and then at trial he'll go into the witness box or call evidence to support that was his object, and then the prosecution can challenge him and call evidence to challenge that case, for instance, to show that he had a keg of gunpowder and his intention, in fact, was to set off that keg of gunpowder. And whilst it's true he would find it very interesting to see what a keg of gunpowder would do, he must have appreciated that it was going to cause massive damage to all the properties around, and that infected his object, so that on fine analysis at trial on the facts, he couldn't sustain the defence that he sought to put forward.
Well, that would be a scenario that would develop if there was a dispute as to what it was in fact what he was going to do. But here, it's at one stage before that, because what the Crown Court judge is deciding at this stage is whether, if the evidence as set out in his defence statement, if that became evidence in the trial, whether that, even if it was proved and accepted
and unchallenged,
and unchallenged, whether that of itself could substantiate or prove the statutory defence.
Yes.
And what the judge was saying is, no, it can't.
Yes, I mean, I appreciate all of that, but my question to you was what's an issue is whether the judge was right. Why? Explain to us why things don't work out in the way that along the lines that I was just putting to you, that at the level of putting forward the defence case, where the onus is on him, he has to specify his object. He has specified an object of experimentation and personal education. And thereafter, it remains open to the prosecution to challenge his case on the evidence at trial by seeking to show that that object was not, if you like, just to be left there, but one could bring in other aspects of what he must have appreciated was going to happen. Therefore, it couldn't be said that his object was as pure as simple experimentation with no unlawful element.
It could happen that way, my lord, but it would only get to that stage if a reasonable jury could conclude that if what the appellant says is correct, then the defence would be established. Because
in cases on the facts in the defence statement, no defence is disclosed.
Exactly.
That's as far as you need to go.
Yes.
Right.
Yes, and that's what the judge has decided.
So I presume there must be some criminal procedure rule that tells us what is meant to be contained in a defence statement.
There are, although it wouldn't necessarily, I think, shed light on the point I think my lord is raising.
Well, so I'm just wondering about the level of detail one has to get into in a defence statement.
It simply needs to identify the issues and the matters which, in respect to the prosecution case, which issue is taken. But what the judge was being asked to rule on was whether the facts set out in the defence statement, if they were unchallenged, could constitute the defence.
Yes.
Now,
and why couldn't they? Because you yourself accept that there are levels of experimentation which are lawful.
the reason why
So just to pursue the thought. So if unchallenged, where he said, my object is experimentation, and that can be lawful, if just allowed to rest there with the prosecution doing nothing to challenge that, why wouldn't that be a good defence?
Because the respondent submits that is not sufficient detail in order to discharge the burden, either in respect of establishing what the object is for the purposes of the section, or that object is lawful. And the reason I say that, my lord, is because the object for the purposes of the Section 4 offence is the use to which the explosive substance will be put. Now, that is not proved or even identified simply by saying, I'm going to experiment with it. It does require an accused to explain what's going to happen in relation to the detonation of the substance.
So, I'm sorry to come back here with the other possibility that I put to you. So if that is right, why wouldn't it be enough to say experiment to produce an explosion to the level of a firework?
Well, that may be sufficient to identify an object, but then the next step is, can the accused prove that is lawful? And in order to prove it's lawful, the onus being on the accused, he has to produce evidence at the stage of the defence statement, explain what it is that makes it lawful. And at the moment, there's simply an absence of any.
But are you saying setting off a firework is unlawful?
I'm not saying that setting off a firework is unlawful, but this wasn't a firework.
No, but on the hypothesis I'm putting to you, that's what a defendant is saying. I wanted to experiment to produce an explosion to the level of a firework. Fireworks, let's say, setting off a single firework being a lawful thing to do. Why wouldn't that be enough?
Well, my Lord, first of all, it's not this case, but secondly, that would have to be examined critically to see whether there was any evidence of that or any explanation. And at the moment, there's simply an absence of any explanation as to what was going to happen with these explosive substances.
The problem is you're eliding the difference between possession and use. The relevant object is the object of possession. It's not the object of use. And if you're possessing it with the object of experimentation, you may not even yet have decided how exactly, what experiments you're going to do. But it doesn't mean that on your approach, somebody who had it in his possession in order to carry out experiments could not have a defence if he hadn't yet decided the form that the experiments were to take. But I doubt whether that can be right.
No, because if someone in that position, a hobbyist who stores...
Or it could even, the problem I've raised with you could equally apply to a commercial laboratory or a government laboratory.
But someone in that situation would be able to point to circumstances and levels of detail that would be sufficient to discharge the burden. For example, a university laboratory would be able to point to things such as a certificate to permit possession.
Well, that's got nothing to do with it. If he hasn't got a certificate, charge him with not having a certificate. But he's been charged with possession without having a lawful object for his possession. So that's what we need to focus on.
But there are further points. The accused in that case, if they were charged, would be someone starting from the point of they are a person who is authorised to possess. I know that's not the answer, but that's the starting point. They would be able to point to a syllabus, to qualifications, to the circumstances in which the explosion was going to take place, a whole range of matters based on skill and expertise that would shed light on what it was that was going to happen to the substance in question. Whereas here, it's impossible for the accused to present any of that because of the circumstances in which he has made and possesses this material and what he intends to do with them. The only thing that's known is that he wishes to experiment. What's not known is whether it's going to be simply these materials, whether they're going to be mixed together, how they're going to be detonated. There's just simply an absence of evidence or information. And where an accused has the burden of proving what the object is and it's going to be lawful, any doubts or gaps or uncertainties operate against an accused. And so what the respondent submits, my lord, is that it is the onus, it's the reverse burden, which is designed to counter the mischief in relation to explosives, which is their inherent danger, the inherent risk, which informs what it is that the accused has to prove. Might I take the courts to one part of the Court of Appeal's judgment, just to try and highlight the point I'm seeking to make. Let's take the court to paragraph 42 of the Court of Appeal's judgment, which is behind divider 7 of the core bundle. It begins at page 89. And it's on page 99 of the e-bundle and page 79 of the paper bundle. And in paragraph 42, what the court says, relying on Fagan and the Attorney General's reference case and Riding, is that what they're required to prove, what the accused is required to prove, is an affirmative or positive object, simply in the sense of there's a reverse burden. It's not a new concept of a positive lawful object. It's simply that the accused can't be neutral. They have to actually identify what the object is. And then, at the end of that paragraph, the court identifies two matters which the accused must show in order to discharge the burden. The first is the use to which the explosives will be put. And the second is that such a use is lawful. And the point the respondent seeks to make is that in this case, the appellant simply has not shown the use to which the explosives will be made. It's unknown.
Right. But, I mean, the way you're presenting the argument, it does make it sound like a sort of pleading issue. Because in due course, one might expect the defendant to go into the witness box and there'll be all sorts of evidence, both given by him and challenged by the prosecution, about what he thought was going to happen when he conducted his experimentation. But you seem to be saying all that has to be reduced down into the defence statement, and if it isn't, then his defence can be knocked out at that essentially pleading stage. Is that right?
The defence isn't being knocked out, but what the judge is saying is that this is insufficient. Because if my lord looks at paragraph 43 of the judgment
Of the Court of Appeal.
of the Court of Appeal, what had been argued was that the curiosity or experimentation was of itself the lawful object. And the point the Court of Appeal makes, which the respondent submits is correct, is in fact it's not curiosity or experimentation which is the object. The object is the uses to which the explosives may be put.
Is it the reason for the explosion?
It's the circumstances of the explosion.
Well, I know that your submissions have been addressing the question as to how it's carried out. But the difficulty I have at the moment is understanding how the explosion of itself can be an object. And I wonder whether the lawful object has to be something beyond the explosion, the purpose for which the explosion is being caused.
Well,
And now we may be hampered here by the fact that the defence statement addresses the object of manufacturing. But the defence have taken their stand on that. They say they're content that that should be the basis on which we address it. If you then draw a comparison between a university chemistry department and someone experimenting in the back garden, it may be said that there would be a clear purpose for the explosion, if indeed they are used to cause an explosion, because often, although they may be explosives, they would not actually be exploded in those circumstances. That's another point.
yes, well, one of the points we make in our printed case is that in this case, although the appellant has said that his object is experimentation, it's not necessarily clear that there is any object in his case, because for the point that my lord makes, in a university, the reason that an explosion takes place is clear and readily identifiable. In the present case, there is no obvious purpose. The appellant has no skill. All he is saying is, I'm doing it because I want to.
Well, if he's able to detonate explosives using a mobile phone, he's certainly got a level of skill beyond mine.
Yes.
And anyway, why shouldn't the education be to acquire skill, which you don't start off with?
But I come back to the other, to my principal point, my lord, which is the object is the use.
Right. And can I just ask you, pursuing that, how this fits with the self-defence cases? Because as I understand it, the object of self-defence is an object expressed really at quite a high level of generality. Whether or not the use of the bomb in self-defence will genuinely be lawful will depend on the circumstances in which it's used, whether it's the disproportionate reaction to the threats that was experienced and so on. So you can't say at the outset whether it will necessarily be a lawful use of the bomb. It's just that there is a general object which could be lawful, namely self-defence, depending on the circumstances in which it happens to be used. But I rather got the impression from Fegan and the Attorney General reference case that all that needed to be specified for the defence, at least to get the defence off the ground and into court on it, was to say, in relatively broad terms, the object was self-defence.
Whether that could be left in a Fegan-type case would depend on the circumstances, because even
Sorry, on what circumstances?
Well,
because when the bomb comes to be used, it may or may not count as self-defence.
even in a case of self-defence to a charge of murder, it is open to a judge to withdraw from the jury consideration of that defence if the facts are incapable of establishing that defence. Now, the courts in Fegan and the Attorney General's reference case concluded that on the facts, a reasonably directed jury could have found in favour of the defendant on that point. But
But the point was the defendant simply saying, I had this for self-defence. Isn't that all they said?
Well, they went further than that. In Fegan, for example, the appellant there had married someone from across the religious divide, had been subjected to abuse and threats of violence, and so on. So there was a factual background there,
right?
And he was able to explain what it was that he feared and what he thought was going to happen. And so it went beyond simply an assertion.
No,
Well,
but I'm sorry.
The evidence went beyond an assertion.
Yeah.
I mean, that case was decided at a time long before defence statements, I imagine. So the matter was judged in the light of the evidence that he gave.
Well, my lord, the first stage was whether the assertion that was made would have been capable, and whether.
But almost ex hypothesi, he could not have specified in detail the conditions in which he was going to use it, because the attack might come from anywhere. You know, he didn't know when, where, in what circumstances he was going to be attacked, and yet whether he had a good defence of self-defence would depend on when, where, and the circumstances in which he was going to be attacked. But you seem to be saying that in order for someone to be allowed to run the defence, they have in their defence statement to specify all those things.
Well, they have to be able to establish sufficient circumstances for a reasonable jury to conclude, first of all, that the object can be identified, and secondly, that it would in fact be lawful. And in my submission, an accused does have to do that at the stage of asking a judge for a ruling or a judge ruling whether or not what is contained in a defence statement is capable of substantiating the defence. And the reason it was done in this way, my lord, is because what was being argued in the Crown Court and then in the Court of Appeal was that experimentation was not unlawful per se, and therefore, if it was correct that the appellant was experimenting, that's the end of the inquiry. That's the issue that the Court of Appeal was considering. But in the submission of the respondent, that can't be the end of the inquiry. The onus requires the accused to identify with precision what was going to happen in order to discharge the burden.
That's your case, anyway. Can I just ask you a slightly different point? I mean, the defence said that this was something to do with his autism, that he was obsessed by this. And so the sort of experimentation he was carrying out probably wasn't the sort of experimentation that you or I would be doing, even if you were interested. Do you look at it from his point of view in deciding whether there was a credible object?
Not in terms of whether it's a lawful object. There may be an argument in other offences where the equivalent of lawful object is reasonable excuse. But here, when the focus of the inquiry is the use to which the explosives are put and whether that is lawful, there's no room for that kind of consideration, subject only to the usual defence or excuse that arises in the case of...
But it goes obviously to the genuineness of his case, doesn't it?
Yes.
But it doesn't deal with your point that he needs to show a use beyond just experimentation.
Yes, and it wouldn't affect the lawfulness or otherwise of the use, unless it was an insanity case, which this plainly isn't. My Lord, following that, those submissions, I think I have probably traversed the scope of what it is I was going to submit to the court. But can I try and summarise it in this way? What the Court of Appeal decided was that in order to discharge the burden, the accused has to show two things. First, the use to which the explosives will be put. And secondly, that use will be lawful. And the point the respondent makes is that it is not enough and can never be enough in order to show those two things for an accused simply to say that I was doing whatever it was I was going to do for the purposes of experimentation. He needs to identify what it is he's going to do and demonstrate that that act, that use, is in fact lawful. And the judicial role here, which the judge in the Crown Court undertook, was to rule whether, in the appellant's case, the matters set out in the defence statement were capable of discharging that burden. And he concluded that they weren't, and the respondent submits the judge was entitled to reach that conclusion, and in fact was correct to do so. And, my Lord, in relation to the certified question, the respondent's submission is that personal experimentation and self-education are not of themselves objects for the purposes of Section 4, but a person who possesses explosives for that reason must show how they are going to be used in order to identify the objective, and then go on to prove that that was lawful, and that there is no need for proof of any ulterior unlawful objective, as the certified question phrases it, in terms of a substantive criminal intent. So, my Lord, that's the way the respondent would analyse the position, to say that the Court of Appeal was correct to conclude that curiosity and experimentation are not themselves objects.
Yes, thank you very much, Mr. Malby.
May I just deal with one point in reply, and that relates to the question of the defence statement. Our submission is that quite clearly, both at first instance and in the court below, the decision was one of principle rather than a defect in defence statement. Indeed, until this afternoon, the appellant was not aware of the suggestion that the case was dismissed simply because there was some defect in detail in the defence statement. That appears to be a new point, or certainly the development of a point which had not been anticipated. And if my learned friend is right in saying what he does, then it would be easily cured by an addition to the defence statement asserting that the appellant was proposing to carry out the test in his back garden. He could indicate the size of the back garden, the isolation of the testing from property or people, and so on and so forth. The fact that this has only just arisen is relevant to this extent. The appellant was interviewed 21 times and answered each and every question that he was asked in those interviews. And no doubt, had it been thought necessary or appropriate to find out in more detail precisely how he was going to conduct those tests and experiments, we would have been in a position to trawl through those 21 interviews in order perhaps better to explain how it was that the experiments were to be conducted. Probably not necessary in the light of the evidence which the court knows that they were carried out in his garden, and that there is photographic evidence on his mobile phone identifying precisely how the experiments had previously been carried out, and no doubt the inference to be drawn that is how the further experiments with these two substances would have been carried out. We have not introduced that material into the statement of facts and issues simply because we had not anticipated that the real complaint behind the appellant's proposed defence was that there was some defect in the defence statement, and there was a lack of particularity as to the circumstances in which it was proposed he carry out these experiments.
May also be relevant in another way, Mr. Bergen, in that we're dealing here with a defence statement which was drafted on the basis of the object of
Yes.
making.
Yes. Yes, exactly.
Yes, presumably, if the Crown are given permission to amend the indictment, I presume you'll be given permission to amend the defence statement to meet the new form of the indictment.
Of course. But we say that in reality, the circumstances in which it was proposed that the experiments take place is evident, not just from mobile telephones, but from the information he provided the police during the course of those 21 interviews.
Yeah.
And presumably there are rules which, in broad terms, specify the level of particularity required of a defence statement.
Yes.
Can you help us?
Yes, I can.
I'm sure we can look them up.
Yes,
but for those
Lord, they are
if you just give us
under the
references.
Criminal Procedure and Investigations Act 1996, and for those of your lordships that have access to an Archbold, it is at paragraph 1264. For the purposes of this part, a defence statement is a written statement setting out the nature of the accused's defence, including any particular defences on which he intends to rely, indicating the matters of fact on which he takes issue with the prosecution, setting out, in the case of each such matter, why he takes issue with the prosecution, setting out particulars of the matters of fact on which he intends to rely for the purposes of his defence, and indicating any point of law, including any point as to the admissibility of evidence or an abusive process which he wishes to take, and any authority on which he intends to rely for that purpose.
Yes, thank you.
Can I just ask you the question I put to the other side? I mean, how does his autism come into this at all? I mean, does it affect the way we look at his purpose?
Simply demonstrates perhaps an exaggerated desire to learn and understand precisely how bomb-making worked.
Right, thank you.
Well, we're grateful to counsel. We'll take time now to consider our decision. In view of the circumstances, we'll let you have that decision as soon as we can.
Thank you.
And the court will now adjourn.